Chirangi v. The State of MP, 1950-53 CRLJ 1212 MP. The Tale of Chirangi Lohar, Mistake of Fact and the Law. In the remote forests of Bastar, Madhya Pradesh, lived Chirangi Lohar, a 45-year-old widower. His life was simple, shared with his unmarried daughter, his nephew Khotla, and his only son, Ghudsai, aged about 12. The family bond was close. Chirangi, however, suffered from an abscess in his leg and poor eyesight from cataracts. On the morning of 3rd April 1951, Chirangi and Ghudsai set out for Budra Meta, a nearby hillock, to gather siadi leaves. Chirangi carried an axe, a common tool for this work. Somewhere along the way, Chirangi stumbled and fell. When his nephew Khotla came later, he found Chirangi asleep, the axe stained with blood, and Ghudsai nowhere in sight. Soon, villagers learned the grim truth: Ghudsai lay dead, killed by blows from that very axe. When confronted, Chirangi did not flee, deny, or attempt to hide the act. Instead, he told a strange story. "I thought I saw a tiger. My head spun. I didn't know it was my son. I struck in fear." He repeated this to village officials and police. The explanation seemed absurd until medical evidence began to support it. The trial. Chirangi was charged under Section 302 of the Indian Penal Code, IPC, murder, punishable with death or life imprisonment. His defense rested on Section 79 IPC. Nothing is an offense which is done by a person who is justified by law, or who by reason of a mistake of fact and not by reason of a mistake of law, in good faith believes himself to be justified by law. Chirangi claimed he acted under a mistake of fact, believing his son was a tiger, and in good faith, meaning without any intention, mens rea, to kill a human. Evidence of the mind. All four assessors in the trial agreed Chirangi genuinely believed he was striking a tiger. Dr. K.C. Dubey, a psychiatrist, testified that Chirangi's poor eyesight, fever from his abscess, possible heart trouble, and the fall could have caused temporary delirium or a hallucinatory state. In that moment, he could have lost the ability to recognize even his own son. Legal precedents. The court considered earlier cases. Varyam Singh v. Emperor, 1926. A man who killed another thinking he was a ghost was protected under Section 79 IPC. Bonda Kui v. Emperor, 1943. A woman who killed someone thinking them to be a demon was also protected. In both, honest belief and mistake of fact negated criminal intent. Judgment. The High Court of Madhya Pradesh found Chirangi acted in good faith under a mistake of fact. He lacked the criminal intent, mens rea, required for murder under Section 302 IPC. The act fell within the protection of Section 79 IPC. The conviction for murder was set aside. Chirangi was acquitted and freed. Moral of case. This case became a landmark illustration of how Indian criminal law treats acts done under genuine, good faith mistakes of fact. It clarified that without criminal intent, there can be no